रेडी स्टार्ट। पटना हाई कोर्ट के लिए ये 800 वर्ड हो गया, 100 वर्ड्स पर मिनट आज पहली बार। रेडी। मोबाइल नंबर 9507142555 इन पटना बाय MD सद्दाम नियर प्लेटफॉर्म कोचिंग। चलिए रेडी। ऑडियो को लाइक करें, सब्सक्राइब करें और बेल बटन जरूर दबा दें। ये पटना हाई कोर्ट का है, थोड़ा सा अच्छा से लिखिए। अच्छा से लिखा रहा है। PLJR बुक हो गया। ये हो गया आपका सुनील कुमार गुप्ता वर्सेस स्टेट ऑफ उत्तर प्रदेश। चलिए रेडी स्टार्ट। The charge sheet stated that no offence was made out under sections 498A, 304B was made out under sections IPC and under sections 3 and 4 of the Dowry Prohibition Act, 1961. Stop para. In the trial, Sudhir Kumar Gupta under bracket PW1, under bracket close, Mohit Agrawal under bracket PW2 under bracket close, and Manish Gupta under bracket PW3 under bracket close were examined on 30/10/2014, 6/11/2015 and 8/11/2015 respectively. Stop. About 1 year thereafter, during the course of trial on 4/10/2016, an application under section 319 CRPC was filed by the prosecution seeking to summon the appellants/accused for the offence punishable under section 302 IPC, stating that their names were mentioned in the FIR and also in the evidence of PW1 and PW3. Stop. The trial court held that prima facie evidence is available against the appellants for trying them for the offence punishable under section 302 IPC and allowed the application and ordered issuance of summons to the appellants for trial under section 302 IPC. Stop. In the revision filed by the appellants, the High Court by the impugned order dismissed by the revision petition, observing that there are specific allegations against the revisionists and therefore, there is no illegality or impropriety in the order of the trial court. Stop. Being aggrieved, the appellants are before us. Stop para. Mr. Basawa Prabhu S. Patil, learned senior counsel appearing on behalf of the appellants, had submitted that though the names of the appellants were mentioned in the FIR, subsequently they have been exonerated by the investigating officer when the charge sheet was filed, and this aspect was not considered by the High Court. Stop. Placing reliance upon the Constitution Bench judgment in Hardeep Singh versus State of Punjab and others, under bracket 2014 under bracket close 3 SCC 92, it was submitted that the power under section 319 CRPC is to be exercised sparingly and only in those cases where circumstances of the case so warrant, the accused could be summoned under section 319 CRPC. Stop. It was submitted that in the present case, there are no strong and cogent evidence for the trial court to exercise its jurisdiction under section 319 CRPC to summon the appellants for trial under section 309 IPC. Stop. It was contended that when the dying declaration of deceased Silpa contains only the name of Chanchal at the rate of Babita, the High Court and the High Court ought not to have ordered summoning of the appellants for the offence punishable under section 302 IPC. Stop para. Per contra, Mrs. Ruchi Kohle, learned counsel appearing on behalf of the respondent estate submitted that based on the evidence of PW1 and PW3, the trial court satisfied itself that there are prima facie evidence available on record indicating involvement of the appellants in the offence, and the High Court rightly declined to interfere with the order of the trial court summoning the accused. Stop para. We have carefully considered the submissions and perused and impugned order and other materials on record. Stop para. On 19/8/2012, immediately after the occurrence at 9:40 p.m. in her dying declaration recorded by the Tahsildar, deceased Shilpa had stated that she had a quarrel with her sister-in-law Dehrani close Chanchal at the rate of Babita, and that Chanchal at the rate of Babita poured kerosene and set her on fire. Stop. In the complaint lodged by PW1 on the next day, that is 28/2012, he has referred to the names of the appellants. Stop. Though the charge sheet was filed under section 302 IPC only against Chanchal at the rate of Babita, the complainant has not filed any protest petition at that stage. Stop. In his evidence, PW1 has referred to the names of the appellants that his daughter Shilpa in consciousness told him the names of all the appellants including Chanchal at the rate of Babita, and that they are responsible for pouring kerosene and set her on fire. Stop para. Section 319(1) CRPC empowers the court to proceed against any person not shown as an accused if it appears from the evidence that such person has committed any offence for which such person could be tried together along with the accused. Stop. It is fairly well settled that before the court exercises its jurisdiction in terms of section 319 CRPC, it must arrive at satisfaction that the evidence adduced by the prosecution, if unrebuted, would lead to conviction of the persons sought to be added as the accused in the case. Stop. In Hardeep Singh, the Constitution bench held as under. Stop para. Power under section 319 CRPC is a discretionary and an extraordinary power. Stop. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. Stop. It is not to be exercised because the magistrate or the sessions judge is of the opinion that some other person may also be guilty of committing that offence. Stop. Only where a strong and cogent evidence occurs against a person from the evidence led before the court that such power should be exercised, and not in a casual and cavalier manner. Stop para. Thus, we hold that though only a prima facie case is to be established from the evidence laid before the court, comma, not necessarily tested on the anvil of cross-examination, comma, it requires much stronger evidence than more probability of his complicity. Stop. Para. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, comma, but sort of satisfaction to an extent that the evidence, if goes unrefuted. Stop. Finish.